My name is Jeff Senger, and I'm a mediator and arbitrator at JAMS. After graduating from Harvard Law School, I went to the Department of Justice, where I was a civil trial lawyer and a federal prosecutor. I then went to the Food and Drug Administration, where I was the acting general counsel. I then went to Sidley Austin, where I was a partner for about 15 years doing life sciences and commercial litigation, and then I joined JAMS. Mediation is effective because the parties get a chance to craft their own resolution. If you go before a judge, or even more before a jury, the people deciding your own dispute are not you. They don't know it as well as you do. They don't understand your goals for a settlement the way you do. I think it's very important to follow up if a case has not settled at first, because many times it will settle later. I like to keep in touch with parties, to call them again, to suggest another meeting if it would be helpful, because sticking to it often pays off in a resolution. I think I do a lot of my best work before the mediation even starts. I spend a lot of time reading the filings. I like to talk to both parties before the mediation begins, and I find the work done before the mediation can be as important as the mediation itself. When you're prepared for mediation, it's important to start with a good, hard, honest look at your alternatives, what you're going to do if the case does not settle. You need to be realistic about that. That will enable you to decide whether settlement is in your interest or not. I also suggest that parties prepare for a mediation by thinking if there is anything creative that they can do to resolve the dispute, anything besides money. Many disputes appear to be solely about money, but often there are other interests that can be satisfied in addition to money that can help a case resolve. I think it's important for arbitrators to be timely and efficient. The promise of arbitration is that it will be quicker and cost less than a litigated result. It needs to follow the law, the facts, the parties' agreement, and ensure that the result, the outcome of the arbitration is an appropriate one. I like to be a managerial arbitrator who's taking the lead and making sure I'm guiding the process. It is ultimately the parties' process. They've agreed to use this process to resolve their dispute, and I want to make sure I honor their goals in the arbitration itself. I handle all kinds of mediations and arbitrations. I have particular experience with life sciences disputes from my time at the Food and Drug Administration. I also worked on healthcare matters when I was at Sidley Austin. And I handle government disputes from my time at the Department of Justice and the FDA. I was a litigator for 35 years. I've tried many cases before judges and juries all around the country in state and federal courts. I know how judges think, I know how juries think, I know what they do, so I can advise parties on what's likely to happen with their case if they don't settle, which will inform the decision on whether and how to settle. I've found that if cases don't settle, it's usually because of a misperception on one side or the other side about what's going to happen if they don't settle. And I think it's important to step back, to look at it, to reframe it, to see if you can be creative in overcoming it, and use the emotion that you have as an engine driving you towards a good settlement.